State Senator Russell Pierce, the prime sponsor of Senate Bill 1070, wants a chance to defend the state's new immigration law. He's represented by a Washington, D.C.-based organization that filed a motion for Pierce to intervene in the U.S. Justice Department's lawsuit. The group is called Judicial Watch, a self-described conservative government watchdog group. Paul Orphanides is the group's director of litigation, and he joins us now. Good to have you here. Thanks for joining us.
Good afternoon.
Before we get to Judicial Watch and why you're involved, let's talk about the hearing and your impressions of what you saw today.
Sure. I went to both the morning and the afternoon sessions. There were motions to dismiss heard in the morning and motions for preliminary injunction both in the morning and the afternoon. I think that the thing that struck me most about both hearings was that the judge seemed very focused on individual sections of 1070. At one point in the meeting, in the morning hearing, she stopped one of the plaintiff's lawyers short and said, the lawyer had said, we would like the court to enjoin 1070, and she stopped him short and said, well, 1070, it's not a statute, it's not a law. What it is, it's an enactment that has various sections in it. It creates some new statutes and it amends some other statutes. And you need to be very specific about what particular sections you're talking about, and within each section, what particular provisions. So she was taking a very careful, almost line by line review of the different provisions of 1070.
Not necessarily a surprise?
No, not at all. A lot of times, and this particular 1070 is no exception, there are what's called savings clauses, and that's basically a statement by the legislature that if any of these individual provisions in the bill are declared to be unconstitutional for any reason, then the court should allow the others to go into force. A finding of unconstitutionality on one of them doesn't affect the others.
Interesting. We had heard from our previous guest that it seemed as though she was a little more pointed in her questions in the afternoon against the government's lawyers, I should say, as opposed to the morning with the ACLU's lawyers. Maybe a little bit different tone. Did you see a different tone?
I think so, but also, there were some hearings on Thursday, and then there were the two sets of hearings today. So I think they're sort of narrowing or funneling down the different issues, and I think towards the end of the afternoon session, there were some very specific questions and concerns she had about two provisions. So it seems like she'd almost narrowed her thinking down, and the questions that remain were on those two specific provisions.
Talk about those two provisions.
The one concerns determining the immigration status of someone who has been arrested. The provision says that I think every arrestee shall have their immigration status determined before they are released. And she was very concerned that the term arrest is too broad. And the lawyer for the state had tried to argue that what they really meant was like a booking process. This wasn't something when someone is arrested but then released, and that happens a fair amount. If you think maybe in a traffic context, you could interpret that, what goes on there, as that being an arrest and holding people for who knows how long to determine their immigration status. So she was concerned about how broad the term arrest was being used. The other dealt with circumstances under which officers may arrest without a warrant. There was an addition to the particular statute that governs that situation. It now includes language that says something to the effect that an officer can undertake an arrest for if the officer has probable cause to believe that the person committed a public offense that would make that person removable from the United States. And there's just a whole number of things that were questions that she had about that particular provision and what it meant.
I want to talk about your group, Judicial Watch, and
Sure.
why you were involved in this case. And it sounds as if, judging from what I've read, you folks are calling this the most important piece of litigation that Judicial Watch has been involved with. Talk to us about this.
We've been involved in immigration issues generally for any number of years now. And what was so intriguing about 1070 is it includes a lot of different, in one enactment includes a lot of different issues. There are aspects that deal with sanctuary policies. There are aspects that deal with state officers' authority to arrest. There are aspects that deal with soliciting employment and human smuggling. And these are all issues we've been involved in a variety of different contexts. And here they were in one particular lawsuit. So it was really interesting.
the critics of the law will say that the purpose of the law is clear, and the failure of the feds to enforce. These things are clear, but the law itself, and we'll take it generally here as opposed to the judge who kind of went with a scalpel, but we'll take a broader view. The law got the idea, know the intent, know the purpose, but the law itself is unconstitutional. How do you see it?
We don't see it as unconstitutional. We think that there are a lot of, that what Arizona has tried to do is incorporate various aspects of federal law to make sure that what their officers are doing when they do something like arrest, when they try to verify someone's immigration status, is consistent with federal law. One of the biggest problems with some states or even local governments attempt to involve themselves in immigration issues in the past has been they will try to make determinations as to person's immigration status. And this law is very careful that it does not. It relies on the federal government's determination of someone's immigration status.
There's also a concern among those who are against the law that yes, it codifies federal law by way of state law, but the state law is criminal and the federal law is civil. Talk about that dynamic there.
I would disagree that the federal law is civil. There are civil and criminal aspects of federal immigration law. 1070 only deals with criminal aspects. Federal law is very clear that state and local police officers have authority to enforce the criminal aspects of federal immigration law. And what 1070 does it incorporates those federal standards. In one instance, it even explicitly references violations of two federal laws that are criminal laws, 1306 and 1304, which are both part of Title VIII. They're part of the Immigration Nationalization Act. But it specifically is trying to incorporate the criminal aspects of those laws, not the civil aspects of it.
Last question, real quickly. Will you be surprised if she enjoins most of this law, or would you be surprised if she looks over the whole thing and says, we got no business here?
I would be surprised if she would enjoin most of it. There were things she said today in section, the federal government asked her to enjoin Section 1, and she says Section 1 is a statement of purpose. How could I possibly enjoin that? There was no dispute about Section 7, 8, 9, maybe 10, 11, and 12. So there were some things that are not in dispute at all, and there are others that are just sort of generic additions. There's one section, Section 4. I mean, I think it was conceded at the end of the day that there's nothing there that she would enjoin.
All right. Well, good to get your opinions and your views on this. Thanks for joining us. We appreciate it.
My pleasure.